Lori, did you get the instructions for the beginning of the meeting?
I did. I actually found the copy from November.
Okay, I think it's when Larry shares the screen, I think it's going to come up on that as well.
Okay. Are we ready to get started?
Larry?
Yes, we're ready.
Welcome to the June 8th, 2021 City Planning Meeting. Our first order of business is going to be the approval of the adoption of the meeting minutes. Yes, order of business will be, the order of business shall be as follows: call to order and roll call with the recording of the members present, approval of the minutes, reading of the hearing rules, presentation of the dockets, staff presentation, applicant presentation, questions from members, recess for 30 minutes, consideration of the dockets, public comment, rebuttal by applicant, and questions from the members, voting, and adjournment. So prior to the reading of the public hearing rules, first let's start with the adoption of the meeting minutes from the May 25th meeting. If I have any commissioners that have any questions or a motion for the approval of those minutes.
Commissioner Lana, move for approval of the public hearing minutes from the May 25th meeting, 2021.
Maybe you have a second?
Second, it's Commissioner Stieg.
Thank you, Commissioner Stieg. Are there any comments? Questions? Hearing none, I'll call the question. Commissioner Brown? Commissioner Flick, yes. Commissioner Lund?
Yes.
Commissioner Mobley?
Yes.
Commissioner Stieg?
Yes.
Commissioner Weidberg? I don't think we quite have enough for a quorum. It's hard for me to see who's on the call. I have Commissioner Lund, Commissioner Flick, Commissioner Mobley, Commissioner Stieg.
Commissioner Weidberg is on the call.
I see that.
He is just muted and video is off.
Until we hear from him, I don't think.
Approved. Sorry.
Okay, there we go.
Great, thank you. Missy, can I just proceed with the 5?
Yeah.
Great. Okay, so that'll be 5 for approval, 2 and 3 absent. Okay, so now for the reading of the hearing rules. Okay, presentation of dockets. The order of business for each docket shall be as follows. Presentation by the City Planning Commission staff, presentation by the applicant or their representative. The applicant or applicant may appear on their behalf or be represented by a duly authorized agent. Only one representative may speak on behalf of a request and must pre-register with the staff of the City Planning Commission. Other representatives or speakers may sign up to provide comments during the public comment portion of the meeting. The applicant shall be allowed a maximum of 2 minutes. Questions from members. The members shall have an opportunity to ask questions of the staff or the applicant. Recess. The commission board shall take a recess, a 30-minute recess to allow for members of the public to comment. Public comment. Only rules. Only when public comment will be allowed. Only written public comment will be allowed. Live public comment will not be allowed. No member of the public may submit more than one written comment per agenda item. Time allowed for public comment. The public comment form will be made available at the start of the meeting and will close at the end of the 30-minute recess. Form. Public comments must be submitted electronically on the form provided by the City Planning Commission. Any comment missing this information will not be read aloud. Each submission must contain the commenter's first and last name, the commenter's address, whether the commenter is being paid in connection with his or her comments. The agenda item, reading of public comments. A moderator will read into the record all comments pertaining to that item that have been submitted in accordance with these rules. Comments will be read aloud in a normal speaking voice. The moderator will discontinue reading a comment once it exceeds 2 minutes. Rebuttal by the applicant. Following the public comment period, if there's opposition, the authorized representative of the application is allowed a rebuttal not to exceed 2 minutes. Question from members. Following the public comment and rebuttal, the members have an opportunity to ask questions of the staff or the applicant. Voting. Making a motion. The member making a motion shall clearly state their name when making a motion. For example, I, Commissioner Flick, move to approve, deny the request. Seconding a motion. The member seconding a motion shall clearly state their name when seconding the motion. For example, I, Commissioner Flick, second the motion made by Commissioner Flick. Statement by the chair. The chair will restate the motion, confirming who made and seconded the motion. Voting, the chair will request a verbal vote from each member by roll call. Each member will indicate yay to vote in support of the motion or nay to vote in opposition. Presentation of dockets. So first up is docket item 2621.
All right, sorry about that. Zoning docket 02621 is a request to permit a gas station in an MU1 district, an HUC overlay district, and an EC overlay district. The site is currently developed with an existing structure that is used as a retail goods establishment and has previously operated as a gas station. The fuel island has since been demolished. The proposal would renovate the existing structure and add a new fuel island, which would include 2 fuel pumps. Due to the expected cost of the improvements relative to the value of the existing building, the improvements are likely to be considered a substantial improvement, but this has yet to be determined by safety and permits. The substantial development would require the site to come into compliance with all of the site and landscaping requirements. If approved, the site will be improved. If approved, the site will be improved for the current condition, from the current condition, since it will be designed and landscaped in compliance with the zoning regulations, improving its appearance, softening the streetscape, and allowing it to serve as a stormwater management function. In addition, the proposal meets all of the standards of Article 4 and is consistent with the master plan. Therefore, the staff recommends approval of zoning docket 02621, subject to 10 provisos.
Thank you. Do we have someone to speak on behalf of the applicant?
Yes, Miles should be on the line. Miles Martin is on the line.
Hi, yes, Miles Martin here, architect for the project. Thank you, board, for your time today and hearing on this project. This project is relatively straightforward. as recapped in the staff report, this was an existing gas station that is looking to go back in commerce, but with the addition of pumps. By adding those pumps, we are therefore then going to redevelop the site to conform to the CZO with those landscaping requirements, also removing some flags on the site, such as the refuse being outside the property lines, as the refuse storage is now onside the property lines. The addition of bike parking, and the re-imaging of the gas station itself. I have nothing else to present on the topic.
Thank you. Commissioners, are there any questions for the applicant? Thank you, Miles. Next docket item is 3021.
Zoning docket 3021 is a request for a conditional use to permit a minor motor vehicle repair shop and a car wash in an HUMU historic urban neighborhood mixed use zoning district. The subject property is located on square 173 on lot 1 in the Whitney neighborhood on the West Bank. The site is developed with a mid-century structure that was formerly used as an auto and tire repair shop, but the site has been vacant for several years. At the time of accepting this application, motor vehicle repair use was a prohibited use in the HUMU districts. Due to the prolonged vacancy, the property had lost its legal non-conforming use status for vehicle repair use. The applicant requested a text amendment to the CZO to allow small motor vehicle repair shop and car wash to be allowed as a conditional use in the HUMU districts. This text amendment, zoning docket 2421, was heard at the March 9th, 2021 City Planning Commission meeting. During that meeting, the staff recommended modified approval, allowing that a conditional use for small motor vehicle repair shops is in keeping with the master plan, but finding that the car wash use is in conflict with the master plan designation for mixed use low future land use designation, which is generally consistent with the HUMU districts. At the May 20th, 2021 City Council meeting, City Council made a motion to approve CPC's recommendation for modified approval, allowing motor vehicle repairs may be permitted while car wash remain prohibited. At the time of writing the staff report, City Council had not yet adopted an ordinance to effectuate this change. Staff has since learned that the adopted motion does not correctly reflect the intent of City Council, which was to allow both car repair and car washes as a conditional use in the HUMU district. The submitted staff report relies on this inaccurate motion, which will be corrected in the adopted ordinance. The applicant submitted this conditional use application as a companion to the text amendment. It proposes for 1521 Newton Street to be reoccupied as a vehicle repair shop and to add a car wash component to the site. Approval of this item was dependent on the City Council action for zoning docket 2421. The site consists of one rectangular corner lot with frontage on Newton Street and LB Landry Avenue in the Whitney neighborhood. The site was historically used as an auto and tire repair shop, but it has not been in use for several years. The structure from that former use remains on the site. The structure is a vacant one-story masonry structure containing features such as large garage doors that indicate its former use as an auto repair business. The applicant proposes to renovate this structure, which has been vacant since at least 2015 for use as a repair shop and a car wash. The proposal includes 2 mechanic bays, staff areas, a lobby, and office space, as well as a carport for 3 car wash bays. The applicant proposes to renovate the existing structure on the lot with minimal changes, adding a carport to host a car wash station. The motor vehicle repair use would take place in the existing structure on site, while the car wash component is proposed to occupy the space under a newly built carport. Landscaping along both LB Landry Avenue and Newton Street and parking spaces are also included in the proposed plans. Staff finds that the motor vehicle repair shop use is contextual to the surrounding neighborhood, but the car wash use is not allowable based on CPC's interpretation of the master plan and CPC's modified approval of zoning docket 02421. Therefore, staff has recommended modified approval of zoning docket 3021 subject to 6 provisos.
Thank you. Is there anyone here to speak on behalf of the applicant?
Yes, Miles Granderson, representing the applicant. So first, thanks to staff. This has been a little bit of a long one, so it's been a little extra effort. So thanks for that. The small auto repair, both in the text amendment and then here in the CU, have been recommended for approval, so probably don't need to get too deeply into that. As far as the car wash goes, as far as that element goes, Ms. Farley had to touch on that and clarified that, so I don't need to go too far, but it is the intent of the, or it was the intent of the council, and is the intent of the council or the council office to pass the ordinance for the text amendment, which would allow car washes to be a conditional use in this zoning district. But that, of course, doesn't speak to this particular site, and this particular site would require this conditional use, and we would require, of course, agreement that this particular site makes sense for both the small auto repair and the conditional use. If you notice, obviously looking at the site, it is a purpose-built mid-century structure for for small auto repair, so it makes sense to be refurbished and used as such. One thing I think I'd like to note, if I didn't the first time around, is that small auto repair, tire shop, car wash, not exactly the sexiest things to bring to CPC, or to council, and to ask permission to do so. So one thing before we got started is I told the applicant, or asked her, Anna, I asked Anna if she would go through the neighborhood and make sure that she had the support of the neighborhood before we went any further. Honestly, I wasn't quite sure how that was going to turn out. This site has long been vacant, and there's been some loitering there. So there's been some reasons why people might want to see it develop, but you never know, what the result will be. Anna, I drew a circle around where Anna should go, which was her entire block, and also across the street, everywhere that was there. Very surprisingly, Anna came back with 50 signatures in support for the project, and detailed for exactly what her project is. So that was surprising, and a pleasant result, which I think is why we've been able to get to this point. So that being said, I do think that car washing, because it is allowed as an ancillary use for other uses or other car related uses in this zoning district that are allowed, including dealerships, etc., gas stations that are more intense in car use. So we do think that it is appropriate under the master plan as a conditional use. And then the question really comes down to whether it's appropriate here. And for the reasons stated, we think the overall use will improve the site. It has the support of the neighbors, so as not to, so as to be complete. I will note that the Algiers Main Street Association, which is a business association in the area, did express that they were against it. If it was going to happen, they wanted to see some beautification, which we have proposed, but they would prefer that it not be there. But that the residential neighbors that are around and the business neighbors that are immediately there have expressed near unanimous support.
Anything else? Are there any questions from commissioners?
Commissioner Lund, if we could just clarify the text amendment that is proposed by the city council is, what is that again? I could, guess that would be for Joanne.
So the way I understand it is that, so City Planning Commission did a modified approval to the text amendment, finding that small motor vehicle repair shop was in keeping with the master plan, but that a car wash was not in keeping with the master plan for the future land use that most aligns with this zoning district. City Council intended to shift that and find that both of those uses are allowable as a conditional use, but the documentation suggests that they accepted CPC recommendation. So they will change that language in the adopted ordinance once they get to that point. But that has not yet happened, is my understanding. Stephen?
Okay.
It was introduced at the last council meeting as not approving it, and that was an error. So they're going to amend it for the next one because they did not put it in the motion. I drafted the ordinance according to the motion, and that was not the intention. So it should be happening either at the next council meeting or the council meeting followed.
All right. How does that affect us today in terms of looking at this proposal?
So this is Stephen. You're on deadline today, so you have to take some sort of action. I think it really, the council and the planning commission staff are looking at this two different ways. We as a staff find that car washes, because they have sort of an auto exclusive orientation as a general matter, are inherently in conflict with the development objectives of the master plan for this site. And so we think that only the auto repair facility can be approved and that the car wash cannot be approved. And that's our recommendation. The council seems to have taken a different interpretation of the master plan, although I don't believe there was much stated on the record to that effect. And so you ultimately can draw, I think you're considering this site-specific application, and in doing so, you can draw the conclusion that you either disagree with, or that you agree with kind of the staff interpretation and accept the staff's recommendation. You can also view this as the council did and view both elements of the application as being allowable. So your action is not constrained by what has already happened with the council, but at a future point in time, and Missy, correct me if I'm not correctly expressing this, but basically both the text amendment ordinance and this are going to have to be approved or denied in some way. And the conditional use approval, of course, is contingent on the text amendment. Okay,
so this would go before city council.
Yeah, can I ask a follow-up to that, Mr. Kroll? Is this will end up at the city council, right?
Yes.
So one approach for us, so if we agreed with the staff position with respect to the car wash, then it would be up to the council. It would be within their authority to overrule that in light of any action they might take on this overall ordinance that's before them. Is that right?
Yeah, that's correct.
Okay. Thank you.
Are there any other questions from commissioners? Thank you. Next docket is zoning docket 4421.
Zoning docket 4421 is a request by City Council motion number M21-102 for a text amendment to the comprehensive zoning ordinance to amend Article 18 to establish a new overlay district named the University Area Off-Street Parking Overlay, the intent of which is to require one off-street parking space for any increase in the number of existing bedrooms in existing residences, or for one off-street parking space per bedroom for new residential construction. This would affect the area currently under the University Parking Area Interim Off-Street Parking District by making the regulations permanent, and would expand the affected area to include the Leonidas, Black Pearl, and Hollygrove neighborhoods, among others. The University Area Off-Street Parking Zoning District was approved by City Council on September 17th, 2020, where it went into effect immediately. Interim zoning districts are in effect for 1 year, and lapse of City Council doesn't extend or make them permanent. As the 1 year mark for the University Area Interim Off-Street Parking District is approaching, the City Council introduced motion M21-102 at its March 25th, 2021 hearing to make the IZD permanent and to expand the affected area. It has come to staff's attention that Council Member Giarrusso is contemplating a proposed change to the definition of bedroom, which would directly impact this text amendment. Any proposed changes to the definition would need to be included as part of the analysis and recommendation of the University Area Off-Street Parking Overlay District. However, staff has not received the proposed language to include in the report. Council Member Giarrusso is currently working with the Department of Safety and Permits and the neighborhood associations to provide City Planning Commission staff with this new consideration. Therefore, the staff recommends deferral of zoning docket 4421 to the July 13th, 2021 City Planning Commission hearing to provide adequate time to analyze all proposed changes.
Thank you. Are there, is there any comment from the applicant? Anyone from City Council? No. Any questions from commissioners? You can move on to zoning docket 4521.
City Council motion number M21-112 directs City Planning Commission to conduct a public hearing to consider a text amendment to the use permissions and standards for child care centers in the SRS and SRD suburban single family and two family residential zoning districts. This City Council motion references zoning docket 03820, which amended the use permissions and standards for child daycare centers throughout the city, and which resulted in the greater allowance of both child care centers and home-based child care centers in zoning districts throughout the city. Zoning docket 03820 also amended use standards for both home-based child care centers and child care centers. City Council motion M21-112 directs CPC staff to further increase the zoning districts where child care center use is allowed by considering its inclusion in the use permissions for SRS and SRD districts. The City Council motion cites the critical need for increased access to early childcare in New Orleans and notes that zoning docket 038 increased the availability of childcare centers in non-residential districts within the city. Zoning docket 3820 found that there was a gap in supply and demand for affordable and quality early learning centers in New Orleans. This need is acknowledged in Chapter 8 of the Master Plan on Health and Human Services, which states the goal of instituting land use policy that supports high quality childcare and learning opportunities beyond basic educations that are accessible to all children, and the development of neighborhood-based centers that coordinate and deliver a broad range of human services tailored to the populations they serve. Zoning docket 3821 altered the definitions, use permissions, and use standards for childcare facilities in the CZO, resulting in the expansion of zoning districts where childcare centers and home-based childcare facilities were allowed by right and as a conditional use. All but a few zoning districts, including open space districts, the View Carré entertainment districts, and 3 of the suburban residential districts, have an allowance for childcare facilities following the text amendment from zoning docket 3821. Following this zoning docket, the CZO includes 4 categories or types of child daycare facilities under 2 broad uses of home-based childcare and childcare centers. Home-based childcare facilities are located in residential facilities, whereas childcare centers are facilities where care is provided to children who are not related to the owner or operator of the facility. There are 2 types within this category: childcare center small, which allows for up to 50 children, and childcare center large, which allows 51 or more children. The childcare center use is the focus of the present zoning docket and Council motion M21-112. The SRS Suburban Single Family Residential District and SRD Suburban 2-Family District currently allow home-based childcare small as a permitted use and home-based childcare large as a conditional use. Childcare center small and childcare center large are not currently allowed in these districts. According to the occupational license data, staff estimated that there are 5 childcare centers located in the SRS district and 3 childcare centers located in the SRD district. These centers would be considered non-conforming uses in these zoning districts. According to Article 25, these uses are prohibited from expansion or increase in cubicle content. Article 25 also requires that the non-conforming use remain in use and may not cease operation for a continuous period of 180 days if the non-conforming use allowance is to remain. While the non-conforming childcare centers currently located in SRS and SRD districts would be allowed to remain in their current location, they would not be able to expand their operation nor for any reason cease to operate for greater than 180 days. This can present operational challenges because of the zoning location. The SRS and SRD districts cover a substantial portion of the city, including areas of in New Orleans East and on the West Bank that have more limited access to the rest of the city. Expanding the opportunity to host childcare centers in these areas could better support families located in these areas by offering more proximate childcare option. The purpose of this text amendment is therefore to increase the access to quality and affordable childcare services in these specific areas. Staff finds that the use standards for childcare centers can be modified to reduce any significant impact on the surrounding neighborhood from the use. Staff also finds that this use does not interfere with the future land use designations most commonly associated with the SRS and SRD districts. Therefore, staff recommends approval of zoning docket 04521.
Thank you. Are there any questions from commissioners or anyone to speak on behalf of the applicant? City Council. No? Okay, moving on to zoning docket 4621.
Thank you, Madam Chair. Zoning docket 4621 is a request by City Council motion to consider a text amendment to the comprehensive zoning ordinance to amend Article 4, applications and approvals to modify the Neighborhood Participation Program, NPP requirements therein to authorize teleconferencing, virtual and other remote meeting formats to satisfy NPP requirements during a declared emergency by the governor or mayor when in-person meetings are not an available option. Through emergency declaration powers of state law, the mayor has the authority to suspend provisions of the comprehensive zoning ordinance, including the NPP meeting requirements, and to authorize temporary alternatives. The city attorney has advised that approving this amendment will not supersede the mayor's authority. However, in the event that an emergency is declared and in-person meetings are not an available option, this text amendment will immediately give the CPC director the authority to authorize teleconferencing, virtual or other meeting formats to satisfy NPP requirements. This flexibility supports the purpose of the NPP and is consistent with the master plan. Therefore, the city planning staff recommends approval.
Thank you. Are there any questions from commissioners? Next zoning docket 4721.
Zoning docket 4721 is a request to permit a drive.
Robin, one moment. I'm going to have to recuse myself for the zoning docket. Commissioner Witchery is going to take over.
Thank you. Zoning docket 047-21. Robin, is that you?
Yes.
Thank you.
All right, I can proceed now?
Yes, please do.
Okay. Zoning docket 4721 is a request to permit a drive-through facility associated with a pharmacy that will operate in a proposed medical dental clinic in an MU1 medium intensity mixed use district and an EC and corridor design overlay district. The request also includes a request to rescind or amend ordinance 11921 MCS as it relates to the sub-property. That ordinance effectuated a 1987 conditional use granted to the site and a portion of the site and 4505 South Claiborne Avenue, which it abuts, for the purposes of operating an elementary school. The proposed drive-through facility is an appropriate lower impact commercial use and is not likely to result in a detrimental impact on the surrounding areas where a mixture of commercial and residential uses predominate. The drive-through is not ancillary to the proposed medical/dental clinic, which is a use that's permitted by right in the MU1 district. But because the bulk of its customers will be patients who are already at the site for medical treatment, it can be deemed as consistent with the general purpose and intent of the applicable zoning district regulations. It is also consistent with the master plan and meets all the standards specifically applicable to the use. Comprehensive zoning ordinance contains use standards that are intended to prevent or mitigate any potential untoward impacts, and the provisos recommended by staff will augment those protections. Thus, the staff recommends approval of zoning docket 4721, subject to the 9 provisos that are listed in the report. Just a side note, there is a typo in the report that says 8 provisos, but there are actually 9.
Thank you, Robin. Do we have anyone here as an applicant to speak on the behalf?
Yes, this is John Dower with Rosa Sword Architects.
Hi, John. Thank you for joining us.
Thanks. Yeah, so we agree with the staff report and don't have any objection to the 9 provisos, and we're available if you have any questions.
John, could you please state your address for the record?
It's 1100 Poydras Street, Suite 3550.
Thank you. Commissioners, do you have any questions for John? If there's no questions, we'll move on to the zoning docket. Is that 044-21?
Yes, good afternoon. Subdivision docket 4421 is a request by David A. LeBouf Jr. to re-subdivide lots X and 10-A-1 into lots X1 and 10A1A, located in an HURD2 historic urban 2-family residential district. Lot X is currently developed with a single-family residence, and lot 10-A-1 is undeveloped. The proposal would reconfigure the existing lots into 2 new lots of record, resulting in new dimensions and an irregular shape on lot X1 by moving the rear yard lot line of existing lot 10-A-1 36 feet and 2 inches towards Greenville Street. The applicant has stated the purpose is to allow the existing residential dwelling at 211 David Street more yard space in the rear, while ensuring the lot fronting on Greenville Street meets base zoning district and bulk yard regulations. It has been reviewed by Policy B in accordance with Article 3, Section 3.2.2, and staff finds the proposal doesn't meet all of the 3 criteria. In addition to Policy B, CPC applies a rule to subdivision regulations which create an irregular shape. Typically, the City Planning Commission approves subdivisions with irregular shape that propose an extension from the rectangular lot as long as it's less than 50% of the rectangular portion of the lot. As shown in tables 1 and 2, the dog leg of the proposed lot X1 is 1,150 square feet in area, which is about 43% of the entire area of existing lot X. Therefore, proposed lot X1 does not meet the standard generally applied by the City Planning Commission, and this report recommends a proviso to reduce the size of the quote-unquote dog leg in order to make the proposal more acceptable. The proposal, however, does not interfere with the plan for the 21st century's residential low-density pre-war future land use designation, and otherwise meets the other subdivision regulations and is eligible for approval. For these reasons, the staff recommends tentative approval of subdivision 4421 with the final approval subject to 4 provisos.
Thank you. Is there anyone here to speak on behalf of the applicant?
Yes, I am. This is David LeBouf. Thank you for the time. This is supposed to be.
Can you please state your address for the record, please?
I live at 211 David Street. This is my personal home. Yeah. Well, I thought this would be a much simpler process than what's been going on. I've been trying to buy this lot for 3 years, basically ever since I bought this home on lot X1. My family and I love this home. The only thing that would make us possibly move is the lack of outdoor space for our family. This is really just an opportunity for us to make this hopefully our forever home and stay here for a very long time. I consulted with the Planning Commission with the government about the size of the lot that had to be existing once I cut it. They told me if I got it to 90 feet, it wouldn't be substandard and we shouldn't have too much of a problem. So I'm hoping for full approval minus that one proviso that Joseph spoke about and keep it at the original plan, please.
Thank you. Are there any questions or comments from the commissioner for the applicant?
It's Commissioner Lunn. Just Mr. LeBouf, I believe Joseph said 4 provisos.
Yeah, the fourth one where we change the size is the one that is my concern. If I can only go to 15%, it doesn't make sense for me to do this. Again, this 10A A1A lot that would be created is actually the same exact size as the current X1 lot. This is simply the shape of the lot that is the issue. I've talked to the neighbors, one of which owns a property adjacent to the lot that sold me this lot, and there's no problem with that. It really would have any difference other would be my backyard versus the other backyard. The alternative for me personally, what I would have to build a new house on 10 to A1A and uproot my family across the street, which I would prefer not to do.
Okay, so it's just that one proviso that.
The size, yeah. As long as it's approved with the existing size on the lot that you're seeing right there on the plan, we should be good to go.
All right, thank you.
Thank you, Commissioner One. Are there any other questions for the applicant? Thank you, Mr. LaBeouf.
Thank you.
Moving on to consideration of draft subdivision regulations. Is that where we're going?
Yeah, this is Stephen. That is where we're going. And I think Larry has a document he's going to. Let's give him a second. But just to kind of get started, what this is as you know, as a commission, we and Sabine is presenting this with me. We have for the past 3, 4, 5 years been working to update our subdivision regulations, which govern how land is subdivided in the city, and it's a body of regulations that has been in place since the 50s and was last updated in 1999. And consistent with being developed in the 50s and last updated in the 90s is that it has a very suburban orientation in terms of its regulations, which made a lot of sense for the suburban development that was happening both in New Orleans and across the country in the latter part of the 20th century. But of course, times have changed, particularly since Hurricane Katrina, and there's been a lot of reinvestment and redevelopment within historic, mostly built out neighborhoods where you don't have this kind of suburban cookie cutter lot pattern, but where the lot pattern is highly varied. And so this sort of disconnect between the regulations and their orientation and what we're actually seeing as a staff and as a commission is something that we're trying to solve through this update. I think the other part of it is that since 1999, the city has adopted a master plan and we've adopted a new zoning ordinance, but we haven't modified our subdivision regulations. And so we really need to do that at this point in order to kind of keep pace and keep a consistent set of regulations where the CZO and the subdivision regulations speak to each other and they both speak to the master plan. So in addition to kind of the changes that have occurred since the regulations were last updated, we've also had the experience over many years that the administrative aspects of the regulations are unnecessarily burdensome both to the public and to the CPC staff. And so by updating those regulations, we're creating a process that's easier for the public and certainly easier and faster for us. And Larry, if you want to scroll down slightly. So, when we look at what update is, it should be viewed as an update rather than a starting from scratch. The previous set of regulations formed the starting point, and we basically evolved the regulations. But we did kind of have we do have a lot of the structure from the original regulations built into this new set of regulations. So it's not a complete total change or paradigm shift, but it is an update that we think solves a lot of problems. I think also before we get into the changes, it's good to note that while the subdivision regulations speak to creating parcels of land for development, there's a lot of things that are outside of the subdivision regulations. So the regulations speak generally to the shape and design of lots and their relationship to public streets. But other things that are a big consideration, such as minimum lot size requirements, are not contained within the subdivision regulations. Those are within the zoning ordinance. And so, I say that to say that many of the concerns we've heard recently about the inability to do infill housing because of lot size requirements and the like are not things that can be solved with this this update. But what we can do is create a process that allows for a more efficient, more effective processing of subdivision applications. And then I'll also note that the committee meeting for this by the Zoning and Land Use Committee, the committee voted to forward this set of draft regulations to the full commission with no changes. Since that time, a couple of weeks ago, we've identified a couple other minor things that we would like the full commission to consider, and so I'll note that later on. So I'm going to kind of run quickly through this bullet-pointed synopsis of the changes. In Article 1, we updated the statements of policy to align with the master plan. We've refined the enforcement provisions so that, in contrast to what was done before, where there was a dollar based, fee-based enforcement regime, which wasn't really used, the city is simply not going to recognize lots that are not approved through the subdivision process. That's how we'll achieve enforcement rather than through fines. Regarding interpretations, Bob Rivers, as the executive director, has the authority to interpret the meaning and intent of the regulations. That is something that currently is allowed only by the planning commission, but this will allow that to occur at staff level, which will hopefully help with interpretation. It updates the approval standards for waivers of the subdivision regulations. Larry, scroll down a little bit. In Article 2, which speaks to the review policies for subdivisions, we've fine-tuned some of the review policies, combined some, created new ones based on our experience in the last several years. We've created a placeholder policy, which is policy G, for subdivisions that would involve affordable housing. But this is something that will really be put into effect after the housing opportunity study is complete. And so it's really just a placeholder regulation at this point, with the thought that actual regulations would be developed following the housing study. We clarify that PAC review is required only for subdivisions that propose a new right-of-way or closure of an existing right-of-way. And we've created flowcharts to illustrate review processes, which hopefully will make the document more accessible to the public. Article 3, the application materials. Currently, the NPP requirement does not apply to subdivisions. We're changing that, so there is an NPP requirement for major subdivisions. We're also changing the application material requirements to allow for the executive director to require schematic development plans. The reason we're doing this is a lot of subdivisions that are, a little bit unconventional. Perhaps they create a T-shaped or L-shaped lot, are justified by specific development proposals. And so if you're not seeing the development proposal alongside the subdivision application, you're missing some of the context for the application. So we're giving ourselves the ability to require schematic development plans as a part of an application. And then this seems like a minor one, but it's actually really big and really important, both for us as staff and for applicants, is that in the past, we have required people applying for subdivisions to prove that they have their lenders hold on, kiddo. They have their lender's consent if they've got a mortgage on the property. And so it forces us as a staff to intervene between a property owner's relationship with their lender, which is not where we want to be. It also really prolongs the subdivision process and causes us to have simple applications that just cannot be completed for months and months. So we're now saying that by virtue of submitting the application and signing the form, the applicant is attesting that they have consent from anyone who has a lien or ownership interest in the property, and that therefore puts that process outside of the subdivision process and will make it a lot faster and easier. The next topic, which is ratifications, is one that was raised by the Elysian Fields matter that came up recently. What we're doing is we're bringing subdivisions that we believe as a staff are eligible for administrative approval. We're bringing them to you as a commission for ratification before we approve them. So after we've made the determination that we think they're eligible for administrative approval, you as the commission will ratify that determination saying, yes, they're eligible for administrative approval. No, they're not. They require public hearing, etc. And then we will process the application based on that. And that, of course, cures the problem where we process an application all the way to approval as administrative, and then you get to the ratification phase and you disagree with that classification. So we think that solves that problem. Regarding recertification, we're clarifying that recertification may occur only within 6 months of the original certification. Currently, there's not an end date, so we're trying to create a finite timeline there. For final subdivision plan requirements, we're augmenting the requirements relative to homeowners associations or similar entities that are going to have responsibility for recreational areas and community facilities that are not owned by the public. So continuing to Article 4, we've really tried to modify the design requirements which speak to things like block length, dead ends, cul-de-sacs, that sort of thing. We've tried to modify them so that they're not solely regulations that make sense within a suburban context where you want long streets that have limited access and which culminate in a cul-de-sac. And we've made them adaptable to the various neighborhoods we have in the city. And so as opposed to having a requirement that every block be between 300 and 1,000 feet in length, that the length of a block should have a relationship to the width of the lots on that block, so that you've got block lengths that are shorter in older neighborhoods where that makes sense, and longer in suburban neighborhoods where that makes sense as well. We've clarified the language about when things like flag lots and double frontage lots may be acceptable. And then the last two bullet points are things we really grapple with a lot, including this application we saw a minute ago. The current regulations are silent as to whether split zoned lots are acceptable. Up until 2015, it was standard practice to approve split zoned lots. When the new CZO was adopted in 2015, there was language within it, and is language within it, that implicitly discouraged split zone lots. You also have the fact that split zone lots are harder to regulate because you have to figure out how to apply two different sets of regulations to them. And so what we've done in the last 5 years is created a practice where we support split zoned lots on the condition that the split zoning be remedied either through a zoning change or through a minor map adjustment. And the new regulations would codify that practice, requiring zoning change and minor map adjustments for new split zone lots, except in special circumstances where the commission finds that that requirement is not necessary. The last regulation was really the issue we saw just a moment ago. The current regulations are silent as to whether unusually shaped lots, so L-shaped lots, T-shaped lots, that sort of thing, whether they're acceptable. Again, they're written for suburban subdivisions where everything is expected to be either a rectangle or a wedge shape if you've got a cul-de-sac. And so they have language that says side lot lines have to be perpendicular to front lot lines, which in practice says you can only have a rectangular lot or a lot that's more or less rectangular. But what we see is that in older parts of the city where lots are small and many lots have minimal outdoor space, there's a desire among people to create outdoor space by peeling off a piece of a neighboring lot. And the one we just saw is a perfect example of that. And so what the draft regulations contains, we do want you to kind of think about this a little bit because we don't know whether this is a perfect solution or not. But what we've put in the draft regulations is something that codifies what we've been doing recently, where we've said, if you've got a minor L shape, which is where the kind of the dog leg of the L is 15% or less of the rectangular main body of the lot, that's okay. But if you've got a major L shape, which is where the dog leg is more than 15%, that's not okay. And so that, we've seen a number of these L-shaped subdivision applications recently, including this one a moment ago, where we're saying, yeah, you can do an L shape, but the area that you add has to be relatively small. And, that doesn't meet the needs of the person who's making the proposal. And it may or may not be a good solution. But at any rate, what we've done recently is what we've put in there as a suggestion. Other approaches could be taken. For example, in suburban neighborhoods, we could basically not allow L-shaped lots because you have a more consistent, homogeneous pattern of rectangular lots, but take a different approach in the older neighborhoods, historic core zoning districts, historic or urban zoning districts, where lots were subdivided long before the advent of any subdivision regulations, and where you do have a highly varied lot pattern. So that's a conversation we would like to have. And then finally, we've made some formatting and miscellaneous changes, hopefully simplifying language, reorganizing section, adding graphics and flowcharts. So that's basically the presentation that was done to the committee a couple of weeks ago. Since then, a couple of things have popped up that we'd like to put on your radar and suggest some additional changes. So Larry, if you can scroll down to the next page. That will be a memo that was published alongside, and it's basically a supplement that clarifies that if a subdivision is not completed within a certain time period, that we can close it administratively. So basically a year to create the administrative aspect of the process. The reason we need this is because you have a lot of subdivision applications that come through, are processed, are deemed eligible for administrative approval, and then we just kind of need to ensure that taxes are paid or lender consent is provided or some other requirement is met. And, because the owner no longer wishes to pursue the subdivision or there's some other hiccup, that's never done. And so the applications remain open, for an open-ended period of time. And so we'd like to create the ability to administratively close these applications. So that's, we've got some language, which is shown here on this document to that effect. And then Larry, if you can just scroll down a little bit farther, next page. This is another set of changes that were, Larry, just scroll down to the next page if you could. All right, and so this is a issue that came up last week, and it really has to do with the mechanics of how a subdivision is appealed to council. It's kind of inside baseball, very technical, but it does make a difference. Right now, subdivision that is appealed to council requires something to be filed with the clerk of council and a copy to be filed with the planning commission staff, and that the planning commission staff is required to assess a fee. And the council's deadline to consider the appeal is based off of when those events occur. Most of the time, the two filings happen at the same time, so there's no problem. occasionally and recently, there will be a gap between when the two documents are filed, which has the effect of, for various reasons, compressing the timeline in which the council has to consider the appeal. And basically just, we had an appeal of an application on Crowder where the transmittal to the council could not occur until after a month after the applicant had filed the appeal. And so that put it on deadline before the council immediately. So the solution to this is to treat subdivision appeals the way we treat zoning dockets and really everything else we deal with, which is to require the appeal to be filed only with the Planning Commission, not also with the Clerk of Council, and that we will then transmit that appeal to the council upon receiving it and determining it's complete. And this will just make things a lot smoother and also consistent with the administrative process we use for other application types. So that basically covers it. And Sabine and I, of course, are happy to hear any questions you have. But that's the gist of the regulations that are before you.
Thank you, Stephen and Sabine, for your work. This is great work. We're always looking to streamline our processes and be more efficient. Is there any, are there any questions from commissioners?
No, I just wanted to, as the committee chair, I just wanted to underscore a couple of things that Stephen said. This recommendation is being brought to the commission after the review by the committee. It has the full support of the committee, and this is a lot, and we understand that. And so we're open to the comments of the commission, especially the nuanced piece around individual lots, and it's fascinating that we had that issue right before that exemplifies that point that Stephen brought to bear. I do also just want to say extraordinary work and an extraordinary amount of work was done by staff on this. So thank you to Stephen and the team that did this work and put this together.
Thank you, Commissioner Weber. Are there any other comments or questions?
Hi, this is Commissioner Lund. And yes, Stephen, about Article 4, the regulations about L-shaped and T-shaped lots. So actually voting on this today, it would be keeping it at the 15% maximum increase of the current lot length or area.
Yeah, what's before you today basically suggests that we continue to do what we've done recently. And we put that out there as, to start the conversation around that. If that's something that concerns you as a commission, it's something, you don't have to vote today, so we can defer this after receiving feedback from you and fine tune that a little bit. We can proceed with it. If you're comfortable with it, it's really up to you.
Okay. And also I think this is just the one word in that third bullet item, fourth bullet item, parallel should be perpendicular to front lot lines, right? However, there's language that requires the side lot line to be perpendicular. It says parallel.
Yeah, it should be perpendicular.
So it is still the changes are still requiring that lots have perpendicular sidelines, right?
Yeah, so the regulations say in general, you have to have perpendicular sidelines. And so anything with a T or L shape just can't meet that requirement. And so the 15% rule is intended to provide flexibility to do something that deviates a little bit from that rectangular requirement. The problem is, I think, that a lot of people want to deviate a lot because if you're trying to pick up additional yard space, you can only kind of pick up what's next to you. And if the outcome of that is to create a lot that is highly irregular in shape, that's kind of what outcome you want to, that's the outcome you're searching for, because that's the only option that's available to you. And so I think in practice, the 15% rule creates more flexibility than the most strict reading of the regulations that we have.
Mhm.
It's just a question of whether it creates enough flexibility.
So it allowed for the 15% increase, but there would still need to be a meeting, a perpendicular 90-degree meeting of side and front lot lines.
No, so the 15% basically creates an exception to that. You can have sidelines that are not perfectly perpendicular, but you're constrained by that requirement.
And what is the difference between a minor L shape and a major L shape?
So we're making the major minor distinction is a minor L shape is where the area that you're picking up that's basically in addition to the existing rectangular lot. So if you've got a rectangular lot and then you turn it a little bit to the right or left to pick up a piece of a neighboring lot, the 15% is that extra portion that would be 15% or less of the area of the original lot that you're starting with. So basically the numerator is the additional area, the denominator is the area of the existing lot. So if it's under 15%, we're calling that minor. That has to do, it's really based on an interpretation of what's considered minor in the zoning ordinance, where there's a distinction between minor and major, essentially zoning changes. And so we've taken that distinction and applied it to the subdivision regulations. So minor is where the additional area is less than 15% of the original area. Major is where the additional area is more than 15% of the original area.
So it relates to the same thing, right? Yeah, thank you. I'm so happy to see this. And I know, it's been a long time coming and a whole lot of work. So thank you. I do have a concern about, we'd like to see us be more flexible.
And this is David LaBeouf, and I would appreciate you being more flexible too. Thank you.
Okay, thank you. So thanks, Stephen. That's it.
Stephen, I have a question. What's the typical timeline for administrative approval? You're giving a timeline of a year, but I'm just curious, what do you normally see?
Yeah, so I'll speak to this and Sabine can chime in as well. It varies. Under state law, we have 60 days to take action. And so our action is usually, if we're doing something administratively, saying it's approved, but we can't issue final approval until you give us consent from your lender. And that is something that may not add any time if they've already got that consent. It can add months, years, without exaggerating, if it's something they have to seek out. And if you're seeking it from a Bank of America or some, national and international institution, it's a lot harder to do than if you're going to Gulf Coast Bank or some local institution. The other things that can add time are if the subdivision is eligible for administrative approval, provided that a wall be fire rated because it's going to be within 3 feet of a new property line. And so in that case, the construction needs to occur before the approval can occur. So I think to answer your question, we shoot for within 2 months. And we do what we as a staff have control over within 2 months for sure. There are sometimes things that are outside of our control and really more on the applicant side that can add time, basically.
Thank you. Are there any other questions?
I have a question. This is Commissioner Mobley. Section 3.2, 322B.5. I'm interested in why the shift in language from parties on the contact list, which is used in points 3 and 4, to those impacted by the proposal, and how we were defining those impacted by the proposal, or whether that distinction was made with intention behind it or was simply a change in phrase. Thanks.
Would you mind repeating the section? I just want to go a bit quickly.
Sorry, 3.2.2 B, bullet point 5 under it.
So this is all speaking to the requirements of the project NPP, correct? I want to make sure I'm looking at the right section.
Yeah.
And the last bullet point is a statement as to how those impacted by the proposal will be provided an opportunity to discuss the request if issues or questions should continue or suddenly arise. And you're contrasting that, I think, with who's required to be noticed as part of the NPP. And so there's just a shift of language. Is that correct?
Yes, I am asking
Okay.
if the shift of language is intentional.
It's
Yes.
yeah,
okay.
yeah. So it's not intentional. This language was basically copied and pasted out of the zoning ordinance. It's the same language that's used to describe the NPP process for zoning changes, conditional use applications, and the like. So I don't know that there's certainly no intentionality between that change. I think it's just, you know, a product of whoever wrote the language in the first place when the CZO was created.
Okay.
Thank you. Any more questions from commissioners? No? Okay, we can move on to zoning docket 4821.
So zoning docket 4821 and the remainder of the items on the agenda, and I think it goes to zoning docket 5021, are new applications that were submitted and received for consideration at this meeting. As we've done at the last few meetings, our backlog has meant that we have at this meeting to consider applications that were deferred from the previous meeting. And so, you know, the next domino falls and we need to defer these 4 items to the next meeting on June 22nd to allow for that.
Okay, so we're going to defer those. Oh, I guess we're now going to stop for recess for the comments portion.
We will. It's just that our recommendation is that those last 4 items, 48 through 51, be packaged together for deferral.
Okay, do we need to make a motion to do that? Sorry, Missy.
You would, yeah, you'll do that after the recess.
Okay. So we can, do I have to read the rules for recess? Sorry, everyone. Missy, you're talking, but I can't hear you.
The rules will be posted when we go into the public comment break. So everyone can just submit according to the rules that will be on the screen, and you can go ahead and ask for a motion now.
So I'm looking for a motion to go for recess for the next 30 minutes. Is there a motion? You're also on mute.
Hi, it's Commissioner Lana. I move that we-
Motions.
Okay, the second.
Mobley made this motion for a 30-minute recess.
I'll second it, Commissioner Lund.
Thank you. What would that time be? 3:23.
3:23.
3:23. Are there any comments or discussion? No, so there's a motion on the floor to go to recess, returning 3:23. Commissioner Flick, yes. Commissioner Lund?
Yes.
Commissioner Mobley?
Yes.
Commissioner Steig?
Yes.
Commissioner Weidberg?
Yes.
And Commissioner Witry? I don't think she's on the call. But that is 5. So 5 yeas, no nays. So we'll go for recess and see you here at 3:23.
Thank you.
Paul, if I missed anything, I'm going to take over for Commissioner Flick. So you just let me know when we're starting.
I think we're ready whenever you are.
Good afternoon, everyone. We're going to call the second portion of this meeting to order. And I believe the public comment has been emailed to us. This would be zoning docket 026-21. And from my notes, the recommendation is approval with 10 provisos.
Can you hear me?
Oh, you need to take roll. Look
Yeah.
at that. Keeping me on my toes. Okay. Let me go ahead and roll through. Commissioner Stieg?
Here.
Commissioner Mobley?
Here.
Commissioner Wiegberg? Commissioner Wiegberg, are you present? We'll come back to him. Commissioner Witry is present. I believe that is all of us. If Wiegberg says hello, we have a quorum. Is that correct, Missy?
Commissioner Flick's here.
Oh, Commissioner Flick, thank you.
The next half hour. Thank you.
Welcome.
We need Commissioner Wiegberg as well.
I am trying to track down Commissioner Wiedberg.
Remember, I count to 10 in these moments. Thank you for everyone joining us. We are just waiting to have a quorum. We'll just be a few moments. Commissioner Lunn.
Present.
Thank you.
Okay, we can move on now with her here.
Thank you, Missy.
Commissioner Wiedberg is present also.
Present. Thank you, Commissioner Wiegberg. Now we can proceed. Zoning docket 026-21. Do we have any comments, Paul?
No public comments on this docket.
No public comments. Would any of my fellow commissioners like to make a motion? The recommendation is approval with 10 provisos.
This is Commissioner Flick. I'll make a recommendation for approval of zoning docket 2621 for approval subject to 10 provisos.
And I'll second that, Commissioner Stieg.
Commissioner Flick and Commissioner Stieg, thank you. Let's go through and vote. Commissioner Mobley?
Yes.
Commissioner Stieg?
Yes.
Commissioner Wiegberg?
Sorry, yes.
Commissioner Flick?
Yes.
Commissioner Lund?
Yes.
Commissioner Witry, that is a yes. That would be 1, 2, 3, 4, 5, 6. 6 yays, and the motion carries. Zoning docket 030-21.
All right, we have one public comment from Rebecca Hurst, 800 Barone Street, New Orleans, representing the applicant as a paid representative in support of the application. With regard to the staff's interpretation that a car wash is not consistent with the master plan as being too auto-oriented, I'd like to note that this same zoning district allows gas stations, small motor vehicle dealerships, and drive-through facilities as conditional uses, and even allows car washes when part of a gas station. This all points strongly to car washes not being barred by the master plan as a car wash is no more auto-oriented than a gas station, or for that matter, a car wash and a gas station. That's the last comment.
Thank you, Paul. Staff recommendation is modified approval with 6 provisos.
This is Commissioner Stieg. I'll make a motion to, can I make a motion yet?
Yes, please.
For approval in accordance with staff recommendation. I think we should leave the question of the car wash to the city council. We have an interpretation from our staff that it's not consistent with the master plan. And we know things are being considered at the city council level in a general way. And so I think we should leave this specific question also to the city council to take up at the same time, rather than go against staff recommendation on the master plan.
Thank you, Commissioner Sieg, for your explanation as well. Is there a second?
This is Commissioner Mobley. I'll second Commissioner Stieg's motion.
Thank you, Commissioner Mobley. So Stieg and Mobley, we can go ahead and vote. Commissioner Mobley?
Yes.
Commissioner Stieg?
Yes.
Commissioner Weberg?
And the vote is in favor of Commissioner Stieg's motion. Yes.
Yes. Commissioner Flick?
Yes.
Commissioner Lunn?
Yes.
And Witry, yes. That is 6 yays. The motion carries. Zoning docket 044-21. I believe, Paul, are there any public comments?
Yes, there are several.
Okay. Okay.
Staff has
Thank you.
recommended deferral, but there are comments. First comment is from Maxwell Drodulo, 1340 Poydras Street, representing the Louisiana Fair Housing Action Center as a paid representative in opposition to the application. Louisiana Fair Housing Action Center continues to oppose this amendment to the CZO. We know this is the real issue for neighbors who live next to doubles that have been converted to 16-bedroom buildings, but are very concerned that this is a heavy-handed policy response that will have unintended consequences for years to come. The current practice of converting doubles to student housing likely increases prices for those units, but the solution of requiring parking spaces for new bedrooms will also increase construction costs and housing prices. In many cases, it will increase prices for units that are not being marketed to students, but to long-term residents. More off-street parking spots will also add more paved surfaces and could exacerbate flooding in these neighborhoods. As the CPC staff has pointed out, requiring off-street parking spots also won't significantly alter the total available parking on the street, as each off-street spot removes a curbside parking spot. We agree with the long-term residents of these neighborhoods that a solution is necessary, but instead of making this significant change to the CZO that could negatively affect multiple neighborhoods, we strongly recommend following the CPC staff recommendations. Thank you. Next, from Elaine Green, 6124 Clara Street, in opposition to the application. The proposed university area off-street parking overlay carries far too many economical and social impacts to be adopted. This amendment serves to stifle high-density residential growth that is desperately needed in the university area and its surrounding neighborhoods. Instead of alleviating issues between undergraduate students and homeowners, parking restrictions would only increase tensions between these groups by creating more competition in a market that is already plagued by scarcity. Aside from the economics of this proposal, what makes this amendment truly sinister is the impact it would have on the creation of affordable housing and, in turn, diversity in these neighborhoods. While the motivations behind proposing this overlay are not completely clear, the implications are. Any motion to prevent the creation of accessible quality housing in a city that recently received an F rating in affordable housing will exacerbate the racial and economic gap that exists in the university area. To adopt this amendment would be a serious mistake on the part of this committee and would set back the work that community groups, leaders, and even Mayor Cantrell have done to bridge the historical gap between those who have and those who have not. This amendment is terribly exclusionary, and I implore the committee to reject it. Next comment is from Preston Tedesco, 1533 Broadway Street, in opposition to the application. Both the existing IZD and the proposed extension of the IZD are harmful to the neighborhoods they engulf. the ICD being extended beyond the area where students actually live has only one outcome: the prevention of affordable housing development. The CZO was crafted to help build our city up, and this IZD hinders and blocks this area of New Orleans from following that plan. Before the IZD, a reduction in parking was allowed for affordable developments, but with the IZD, it more than doubles the required parking for these projects, killing the project completely. The area this IZD seeks to engulf has very few students actually living in them. The only projects that follow the IZD guidance would be single-family homes instead of multifamily properties, which benefits more affluent homeowners and prevents affordable rental housing apartments for residents who cannot afford to purchase homes. And the next comment is from Patrick Dario, 1334 St. Roch, in opposition. I'm in full opposition of this text amendment as it is an attempt to solve a small issue of concern for a few neighbors with a measure that will broadly cause more harm than good. The heavy-handedness of this approach is not just wrong, but mean-spirited and has the potential to wildly exacerbate existing racial disparities in housing access to our most vulnerable communities. This one car per bedroom rule is something that a planner like the infamous Robert Moses would have used to exclude Black people from housing access. While Moses is dead today, his racist tactics are still alive in proposals like this. Using bureaucratic tactics to limit Black communities' access to something is a tactic that quiet white supremacists use. In this case, the something is the ability to make modest additions to their homes for years and decades to come, and the ability for dense housing, which the city desperately, continuously needs, to be built. Don't pave over New Orleans to satisfy the concerns of the few at the expense of the many. I urge you to oppose this text amendment to the CZO. Thank you. And one last comment from Thomas Smith, 1022 St. Ferdinand Street, in opposition to this application. Good afternoon. I'm an architect and urban designer. I am writing because I am opposed to amending the CZO to require one off-street vehicular parking space for each bedroom unit for all new construction or renovations. I understand the concern with recent construction in Councilmember Giarrusso's district, but this is the wrong approach. More paved areas for parking will increase impermeable surfaces that shed stormwater runoff, which leads to more flooding. Impervious surfaces increase air temperatures, worsening the heat island effect. More parking areas will also drastically alter the character of historic neighborhoods. Proposed change goes against the city's adopted ordinances, plans, and programs already in place to reduce flooding and improve environmental quality. We must reduce the amount of paved areas in New Orleans, not increase it. We have clear crisis with flooding and affordable housing, not parking. The CPC has already studied the issue and determined that limiting parking permits issued with residential addresses would solve this issue. Please do not pass this unwise proposal. Thank you, Tom Smith. And that is the last comment. So just a reminder that CPC has recommended deferral to second.
Okay, this is
Thank you,
Commissioner
Paul.
Lunn. Commissioner Lunn, I move for deferral of zoning docket 4421 to be considered at the July 13th CPC hearing as recommended in the staff report.
Second from Commissioner Weidberg.
Thank you both. Commissioner Lunn?
Yes.
Commissioner Flick?
Yes.
Commissioner Mobley?
Yes, with full appreciation for a Bob Moses comment and looking forward to whatever new definition of bedroom is to come.
Commissioner Stieg?
Yes.
Commissioner Weberg?
Yes.
And Commissioner Witry, yes. Did I skip over any commissioners? I tried to move to alphabetical order, so I just wanted to make sure I got everybody. Thank you. And the motion carries. The zoning docket will be deferred until July 13th. Thank you all for the public comments. Zoning docket 045-21. The recommendation is modified approval. Paul, do we have comments on this zoning docket?
no public comments, and there will be no public comments for any other docket.
Okay. Paul, you get a break. Do we have a motion regarding zoning docket 045-21 and is modified approval as the recommendation?
Commissioner Mobley, I'll motion for modified approval in support of staff recommendation.
Thank you,
Commissioner
Commissioner
Lund
Mobley.
will second it.
Commissioner Mobley and Commissioner Lund in favor of staff recommendation. Commissioner Flick?
Yes, yes.
Commissioner Lund?
Yes.
Commissioner Mobley?
Yes.
Commissioner Stieg?
Yes.
Commissioner Weberg?
Yes.
Commissioner Witry? Yes. That motion carries. Let's move to zoning docket 046-21. Staff recommendation is approval of this zoning docket, and as Paul had read, there are no public comments. This is about the NPP requirements. Is there a motion?
I'll make the motion to approve staff recommendation.
Commissioner Flick will second.
Thank you, Commissioner Weberg and Flick. This would be to go in support of staff recommendation. Commissioner Flick?
Yes.
Commissioner Lund?
Yes.
Commissioner Mobley?
Yes.
Commissioner Stieg?
Yes.
Commissioner Weberg?
Yes.
Commissioner Witry, yes. That motion carries as well. Zoning docket 047-21. I believe that Commissioner Flick must recuse herself from this vote.
That's correct. Thank you.
This is staff recommendation is approval, and I believe that Robin let us know that there was maybe a clerical instead of 8 provisos, there's 9. Is that correct?
That's correct. That's correct. There are 9 listed in the report. It's just the description. It says, staff recommends approval subject to 8 provisos, but there are actually 9 listed.
Thank you, Robin.
You're welcome.
Do we have a motion for zoning docket 047-21?
Commissioner Lund, I move for approval of zoning docket 47-21 with 9 provisos as recommended by staff.
Thank you, Commissioner Lund. Do we have a second in support of staff recommendation?
Commissioner Stieg will second it.
Thank you, Commissioner Stieg. So we have support of staff recommendation from Commissioner Lund and Commissioner Stieg. We'll move to voting. And there's no public comments on this item. Commissioner Flick? Sorry, she's recused herself. Commissioner Lund?
Yes.
Commissioner Mobley?
Yes.
Commissioner Stieg?
Yes.
Commissioner Weberg?
Yes.
Thank you. Commissioner Witry, yes. And this motion carries. Our next item is the subdivision docket 044-21, and staff recommendation is tentative approval with 4 provisos. Is there a motion from my colleagues? This is the docket item about the re-subdivision on 211 David Street in Bienville.
Correct. And just to refresh, the applicant said that the recommendation as brought forward by staff does not accomplish what the applicant wanted to do, so the applicant may not move forward. Correct, Stephen? Am I getting that right? Thank you.
Yeah, that's correct.
Okay, this is Commissioner Lund. so I may need help with this, with the wording, but my motion is for tentative approval, subject to the first 3 provisos with removal of the 4th proviso that would allow the applicant to move forward with the lot lines as requested. Is that correct? Was that wording accurate?
Yeah, that's good.
Okay, thank you, Ms.
So there's a motion on the floor from Commissioner Lund to go ahead and move forward with staff recommendation, except removing the 1 proviso, and I don't actually have that one in front of me, but to approve the application as submitted. Would that be correct?
Yes, with the lot line located as submitted.
Thank you, Commissioner Lund. Do I have a second?
Commissioner Mobley will second.
Commissioner Mobley seconds. Commissioner Flick, have you joined us?
Yes, I have. Thank you. Yes.
Are you in support or would you of this motion?
Can you hear me?
Yes.
Yes, I am in support of this motion. Thank you.
Commissioner Lund?
Yes.
Commissioner Mobley?
Yes.
Commissioner Stieg?
Yes.
Commissioner Weberg?
Yes.
And Commissioner Witry is a yes as well. So that motion carries with the 1 modification. The application is approved as submitted. Now, this is where I was having difficulty with Wi-Fi on the last and earlier. So are we consideration of the draft subdivision regulations? Is this up for deferral? Is this what we are voting on?
So it's before you and you can act on it or defer it. I think at least from my perspective, the one thing that perhaps requires a little bit more consideration, especially in light of the action of the previous application, is do we have the regulations that we want for L-shaped lots, T-shaped lots, and the like? We basically suggested regulations that would continue to do what we're already doing right now. But there's certainly alternative regulations we can consider. We can make the regulations more accommodating in older neighborhoods and less accommodating in suburban neighborhoods, given the distinctions in lot patterns there, et cetera. So if you're not sure you want to move ahead with the regulations as written, particularly on that item, if you want to defer it for, say, a month, Sabine and I can put together some alternatives and discuss each option and kind of give you a menu to choose from. Bob, and let me know your thoughts if you're okay with that.
Yeah, I was just going to add on to that. If there's any direction that you as a board wanted to give to the staff in coming up with alternative language, we would appreciate that as well.
Stephen,
go ahead.
I was just going to say, Stephen, you're spot on to the discussion we had at the committee, that older neighborhoods that have a history of key lots, ox lots, all of the inconsistencies that are already built in and baked in, that evolution of makes sense versus neighborhoods that were more suburban in their outlay and design that had pretty consistent boxes by and large. I think coming back with a recommendation, because I think that's where the committee was struggling as well, and why we chose to send it forward to treat the commission as a committee of the whole, was because we need a little help from you and Sabine on that issue. So I think the rest of it is in pretty good shape, and I'm comfortable with the rules that have been promulgated by the staff on that. I think this specific issue, if you need some direction, this specific issue is the one, and coming back with kind of a policy alternative of 2 or 3 that we can go forward on would be really helpful.
Might we, and this is a question for you, Missy, might we move to approve with the exception of that section and ask that be revisited separately?
So the way we do this, it's all really kind of a package because it's got to go to the city council for approval as well. And we don't really like to do them piecemeally. And there's no deadline on this because it's regulations. So I think a deferral would be better.
Okay. Then I shall motion to defer and request that Stephen and Sabine take on the age of neighborhood and prevailing lot patterns in consideration of a 15% limit. Also, the pragmatics of a 15% limit would be lovely.
And which meeting you want to defer to?
What is the next meeting, Missy?
Maybe
June 22nd. I don't know if there needs to be more time.
We need a month.
Stephen, what do you and Sabine need?
I think we need until July 13th, and we'll bring you something at that point, and we can defer longer if needed, but I think we'll be in good shape at that point.
Then to July 13th, please.
I'll second Commissioner Mobley's motion, and I'll say that this shouldn't come back to the committee. I think at this juncture, the best thing to do is bring it back to the committee of the whole with those options. So I'm in full support of that.
Before we vote, Commissioner Witry, just a comment, Commissioner Lund, in terms of guidance. I mean, we've already said this a bit, but I just would like to see is more practical flexibility in terms of not the historic neighborhoods for sure, the older neighborhoods, but even what we call suburban neighborhoods. I mean, the city's not very big. To have so much of the city considered suburban seems inappropriate to me, but it is, I realize that's the way it is zoned right now. But I personally like to see more flexibility also in some of the areas we consider suburban, but definitely in the historic core where it can be allowed, where it makes more sense that people have appropriate, dwelling property sizes for their dwelling units with less regard for whether it's perpendicular or, to the front lot line, and more of an interest in a design that fits in a city that is not set up on a grid. Thanks.
Thank you all for your comments. Sabine, did you want to add anything since you're also working on this?
No, I don't. Sorry.
Okay, good to see you. So we have from Commissioner Mobley and Commissioner Wieberg, I believe that we are going to defer this matter to July 13th, and it's not going to go back to the committee. It will actually go to the full commission at that time. Is that correct?
Yes.
So let's go ahead and vote on that. Commissioner Flick?
Yes.
Commissioner Lund?
Yes.
Commissioner Mobley?
Yes.
Commissioner Stieg?
Yes.
Commissioner Wieberg?
Yes.
And Commissioner Witry? So that will move this docket item to July 13th meeting. And I believe, are the rest of the items being asked to be deferred?
Yeah, we would, zoning dockets 48 through 51, we'd ask that you defer them and below go to June 22nd.
So zoning dockets 48 through 51, it's been requested to go ahead and defer those until the June 22nd meeting. Commissioner Flick? Oh,
yes.
We need a motion on that.
Should we make a motion first?
Yeah, yes, thank you. Making sure y'all paying attention.
I'll be happy to make a motion to defer zoning dockets 4821 to 5121 to the June 22nd. Correct. To the June 22nd meeting.
Is there a second?
Commissioner Lund, I'll second.
So let's go ahead and vote. Commissioner Flick?
Yes.
Commissioner Lund?
Yes.
Commissioner Mobley?
Yes.
Commissioner Stieg?
Yes.
Commissioner Wieberg?
Yes.
Commissioner Witchery agrees, yes, and moving forward. Mr. Rivers, is there anything else that we need to discuss?
I think that is everything.
We need to adjourn this meeting.
Motion to adjourn, and nice job driving, Commissioner Witchery.
To keep everyone going. Thank you, everybody.
All right.
Meeting
Thank you.
adjourned. See
Thank
you on
you,
the
Commissioner.
22nd.
Yep, everybody stay well. Bye-bye.
Thank you for sharing.